Speaker says, we'll hear you at your time, otherwise we won't make any progress. Tashreef rakhiye Kazuri sahab.
There were a number of mercy petitions insofar as I am aware.
देखिए Khan sahab, what is the worth of this piece of paper?
My lord,
16 years after the event you write, what does it mean? I don't know.
it's probably setting the record straight.
What record?
That when asked by the author of this book in the context of how
But still it doesn't change anything.
It doesn't because it's much after the execution.
Let's forget this. Let's proceed.
I was only drawing your lordship's attention that this is probably the only other piece of writing, or you may say, which is on the record of one of the persons.
Pirzada's conscience did not prick him for 16 years.
And my lord, your lordship also has that video testimony, which will show.
ये तो अजीब बातें हो जाएंगी ना. We're going to realm completely sort of.
It only shows that he was pointing out that
If we accept that this has even been written by, first of all,
yes,
then why does it take 16 years to write it? So these are too many
the
reasons.
authenticity of this has recently been confirmed in an article written by Mr. Waqar Rana, who had worked with Mr. Pirzada.
You have worked with Mr.
Yes, I have.
Sharifuddin Pirzada.
Yes, my lord.
Did he own up to this thing?
My lord, I am not aware of this. I am not aware of this.
Chale, let's proceed.
So,
आगे बढ़े.
my lord, yes. My lord, my submission before your lordship is that the four questions as framed by your lordship are already on the record. It was a differently constituted bench, but they are part of the order of 12th of December 2023 as well, where your lordships identify these questions.
No order has to be made. It happens automatically by the operation of law, by the
One doesn't attend to Article 9.
9. But under 2, an order has to be made.
Can I take you back a little?
My lord.
I want to understand what is the question of law that's been placed before us? Is the question of law to revisit a judgment of this court? Or is the question of law that the judgment is to be revisited for 2 reasons, because one of the judge made a statement, or because the country was passing through a period of deviation? And would that not entail, is that the question of law?
No, my lord. The second is not the question of law. It's the first which is the question of law. And my submission, based on that first question of law, that Article 4 of the Constitution never having been suspended, and Article 4 of the Constitution, as this Honorable Court notices in the case of Ghulam Mustafa Khar, PLD 1989, Supreme Court, page 26. This was actually even made a part of the PCO, so even the military regime of that time continued with this article and observed that all these requirements will be observed, that in view of that, any order which has been passed in violation of the due process of law can be revisited by the
Without an inquiry.
My lord, it is a question of law that if it comes to light that a particular judgment was a result of considerations other than the due process of law, then that judgment by itself becomes questionable.
But this factum that it was otherwise requires inquiry. We can't just simply look at a video and say this happened. What about the other judges? There are a number of judges on the thing. So, I mean, what I want to legally understand is that when we start addressing a question under 186, is it just a legal question, or this might, as in this case, entail looking at evidence and then also the veracity of that evidence, the interpretation of that evidence? Are we going to entail that, get into that exercise also?
My lord, the immediate response will be based on two
Sir, I want to add one more thing. That can you point out any specific question that is being posed to us in the reference that is to be answered? Specific question for the Supreme Court.
My lord, this Honorable Court itself has posed...
No, in reference. In reference.
My lord, the reference is before your lordship.
Then we should be confined to that question.
My lord, no, your lordship has now framed questions, but if your lordship is looking at the reference on pages 16 to 18, the questions were framed at that time. But may I read those in a minute? They're here. But in order to answer my lord, Mr. Sayyid Mansoor Ali Shah's question, my lord, this arose in the context of an appeal before this Honorable Court, so the issue was open at that time, and it arose in a context where the proceedings had finally concluding in the House of Lords, as it then was called, in the United Kingdom. In the Pinochet case, the House of Lords, again by a narrow majority, had come to the conclusion that Mr. Pinochet needs to be extradited. An issue arose, and your lordship knows that ordinarily the House of Lords never reviews its judgments. Once they have given a judgment, it's final, concluded, and the proceedings were over. But an application was made that Mr. Justice Hoffman who was one of the members of the majority. His wife was part of the Amnesty International, and Amnesty International had submitted an amicus brief.
That was a review, was it?
My lord, but your lordship knows that unlike in our case in the
That would
Constitution of
certainly
Pakistan,
happen if we were to decide a matter. Somebody could file a review and say that one of the judges had a... So I want to really understand the jurisdiction under 186, that a question of law, as I understand, is that this judgment is wrong. Fair enough. Can we just look at it? Can we then revisit the judgment and say it is wrong, or don't we relying on some extra material now, which you say is the interview, which requires inquiry? Could we just take the interview on the face value, or are we to then find out what the text meant, or are we to, some people need to come forward, do we need to cross-examine, do we need to get into all this, or just take the interview on the face value, and that's just one judge? There are a number of other judges who are not saying anything. Maybe they were not under pressure, or they were, we don't know. So my legal question is, are we to dive into an inquiry? Is that envisaged under 186 is my question.
जैसे जरा सा मैं अपनी तरफ से जरा बात करना चाह रहा हूँ। जो अब आपने बातें की हैं आर्टिकल 4 की, जो आर्टिकल 4 कभी भी खत्म नहीं किया जा सकता है, चाहे 233 के तहत भी नहीं किया जा सकता है। आर्टिकल 9 की एक अलग बहस है, मगर अगर आर्टिकल 4 कभी भी खत्म नहीं किया जा सकता है, तब ये हम बात क्यों नहीं कर सकते हैं, इस केस को अलग रखें, मगर हर क्रिमिनल केस में जहाँ के प्रोसिक्यूशन में एलिमेंट ऑफ पॉलिटिक्स इन्वॉल्व हो जाए, नेचुरली एक वक्त में जबकि आइन सस्पेंड हुआ है या एब्रोगेट हुआ है, तो हर को क्यों नहीं राइट मिले दोबारा अदालत का रुख करने के लिए कि जी आर्टिकल 4 तो आपने नजरअंदाज ही कर दिया, तो आपने कहा कि सिर्फ और सिर्फ ये हम इस केस को देख सकते हैं, हम सारे ऐसे केसेस को क्यों ना देखें? ठीक है, वहां अगर मगर आर्टिकल 4 को देखने के लिए कि दरवाजा खुलता है या नहीं, मेरे हिसाब से आपको केस में जाना पड़ेगा। आप सिर्फ ये कह सकते हैं तो नहीं है कि जी क्योंकि उस जमाने में माशाअल्लाह लगा हुआ था तो फलां शख्स को फांसी हो गई तो ये अनकॉन्स्टिट्यूशनल हो गया। नहीं, आपको थोड़ा सा और मेहनत करना होगी कि आर्टिकल 4 का तो आपको दरवाजा है, मगर आर्टिकल 4 के दरवाजे को खोलने के लिए आपको कुछ हमें बुनियादी चीजें दिखाना होंगी। ये जरूरी नहीं कि इसी केस में हो, दूसरे केस में भी हो सकता है, मगर वो अब देखेंगे अगर सदर साहब मुनासिब समझें कि वहां भी रेफरेंस भेजें, क्योंकि रिव्यू का जुरिसडिक्शन खत्म हो गया, तो फैसला तो खत्म हो गया हर लिहाज से, अब रह गया सिर्फ ओपिनियन। तो मैं तो कहूंगा कि अगर आपकी बात को हम आगे ले जाएं और लॉजिकल कंक्लूजन पे ले जाएं, तो हर केस में हम कर सकते हैं ये, अगर नंबर 1 वो उस वक्त में कॉन्स्टिट्यूशनल डिपार्चर हो, पहली बात। दूसरी बात ये कि आर्टिकल 4 के आप प्राइमा फेसाई केस आप एस्टेब्लिश कर पाए। तीसरी बात फिर ये होगी कि ठीक है, आर्टिकल पहली बात भी हो गई, दूसरी बात भी हो गई, मगर हर केस इस बुनियाद पे नहीं खत्म हो सकता है, उस पर ओपिनियन नहीं दिया जा सकता है, मगर उसमें आपको कुछ मजीद दिखाना होगा। और वो मजीद दिखाने के लिए इस केस में एक जज साहब का इंटरव्यू है, दूसरे केस में शायद कुछ और हो सकता है कि वो डीएनए एविडेंस आ गई हो, फॉर इंस्टेंस कि जो जमाने में डीएनए नहीं होती थी, डीएनए एविडेंस आ गई है। तो ये आप इससे एग्री करेंगे या आप इससे डिसएग्री करेंगे?
My lord, I would most respectfully agree with it, because I would respectfully submit that this is something which is now happening in the other jurisdictions of the world as well. In some cases, it is happening in the context of the state having recognized that in politically charged cases, injustices can take place which need to be corrected, has itself specifically conferred this authority on the courts of law.
Makhdoom, that's fair enough. I mean, I'm for fixing miscarriages of justice whenever they happen. It's happened outside another jurisdiction. Miscarriage of justice needs to be fixed. There's no doubt about that. My question right now is the jurisdiction this court enjoys to do that. You know, to understand that. The review is done with, so we don't have any judicial remedy available. So just want to understand whether the window 186 provides is there to fix a miscarriage of justice through an opinion. Is that possible? Because that miscarriage of justice requires probing into the matter, which could be, I mean, you could argue that 186 does include probing into the matter. So that, I want to understand the window, the door that is to be used for the purpose of fixing miscarriage of justice.
If I may just add to my learned brother's thing, I don't think even if we were to come up with a different opinion, there is no question of fixing anything. Now it is only a question of posterity and history. You can't fix anything because the sentence has been carried out. So you can't possibly fix it. So at the moment, all we are faced with is, do you want, as it has been said, do you want this to be used as a precedent in the future? Probably we can give an opinion on that. We can say yes, no, or whatever else we may hear. One judge would.
That too requires some inquiry whether at all this pressure, what does it really mean by this pressure?
Khan Sahab, देखिए, if it was unanimous court or a larger court, one judge would not matter. But if it is the judgment of acquittal and conviction stood on one judge, then I think one judge would matter. And this does not suggest that the other judges were not independent. Let's assume they were all independent, but one judge has categorically come forward and said something. Now we don't need to enter into the realm of was this actually in an interview, because long after the interview came, broadcast on public national television, he could have said, this interview is doctored, this is not my interview, this is not me, my picture was put, or whatever. That has not happened. And he survived a great number of years after that. So one judge, I think, does matter in this case. There may be other cases, okay, you'll say, okay, one more vote goes out, what difference it would make? Nothing. But here it hung by a thread of one vote. It did matter, I think. That's, if it was 4, it would have gone the other way, acquittal, as simple as that. I can't see any other result.
My Lord, there have been a number of questions by your Lordships. May I
be at this juncture see the thing now, because
yes,
I believe it's ready, or you want to continue with your thought?
My Lord, no, I'll answer your Lordship's questions. I have noted them all down. After that, if your Lordship so pleases. Or now, as your Lordship pleases.
लगा दें, वो बड़ी स्क्रीन पे नहीं लग रहा है. You will have to make do with the smaller screen. Can you just turn one a bit that way so everybody can see it? We can see the one and you can volume दे दें.
काफी बड़ा इंटरव्यू सर.
को पैदा हुए चीफ जस्टिस सुप्रीम कोर्ट ऑफ पाकिस्तान 26 अप्रैल 1993 को हुए और 14 अप्रैल 1994 को रिटायर हुए. अप्रैल का महीना डॉक्टर साहब की जिंदगी में बड़ी अहमियत का शामिल है. डॉक्टर साहब से हम गुफ्तगू करते हैं.
और तेज हो सकता है
कि हाई कोर्ट के बैरूनी जो दीवार है, लोग उसके साथ गुजरते हुए भी बड़े एहतियात से गुजरते थे कि अंदर जज बैठे हैं, अंदर बड़े लोग बैठे हैं, वो लोग बैठे हैं जो बड़े फैसले करने वाले हैं. और आज उसी बिल्डिंग में गेट से एक आदमी मोटरसाइकिल पे दाखिल होता है, हॉर्न बजाता हुआ दूसरे गेट से निकल जाता है. तो ये जो सूरत हाल पैदा हुई, ये क्या है?
ये तो मेरे ख्याल में आजकल का जमाना है जिसमें कोई किसी की भी ज्यादा रिस्पेक्ट नहीं है. बाकी जज तो वही है बेचारे, उसी तरह मेहनत कर रहे हैं, उसी तरह का ईमानदारी से ही काम करते हैं. लेकिन लोगों को उनके बारे में कुछ शुबात है, शकूक है, हालांकि मेरे ख्याल में जस्टिफाइड नहीं है. तो बाकी ये जो आप कहते हैं कि वो एहतराम इतना नहीं रहा, ये तो मेरे ख्याल में ये सोसाइटी में सारे महकमों में, सारे अदालों में, हर जगह बस लोग जो है वो बहुत ही मादर पिदर आजाद हो गए हैं.
लोगों का ये ख्याल क्यों हो गया है कि उनको इंसाफ नहीं मिल रहा? किसी सतह पर लोगों को अगर इंसाफ नहीं मिलने का ये तासर है, तो क्या इस तासर को खत्म करना जुडिशरी का काम नहीं?
यह काम तो जुडिशरी का है, मगर वो मुझे समझ नहीं आता कैसे करें. ईमानदारी से काम कर रहे हैं, मेहनत से काम कर रहे हैं, सही काम कर रहे हैं, तो फिर भी तासुर रहता है. ये ज्यादा सियासी मुकदमात की वजह से है. जब वो कोई ऐसा केस आ जाता है जिसमें गवर्नमेंट इन्वॉल्व होती है, या असेंबली को तोड़ दी जाती है, या कोई प्राइम मिनिस्टर के खिलाफ कोई एक्शन होता है, तो वो उन मामलात में शायद जुडिशरी ने उतनी तनदही और उतनी इंडिपेंडेंस से शायद काम नहीं लिया जितना के लोगों के तवक्कुआत थी. उसकी वजह से ये मेरे ख्याल में ये ज्यादा इम्प्रेशन हुआ है.
सब ये कितनी, क्या आप इसको अफसोसनाक बात नहीं समझते कि लोग कहते हैं कि वकील की बजाय जज कर लिया जाए?
नहीं, ये तो लोग तो कहते हैं, मगर मेरे ख्याल में ये ज्यादती है और ये बिल्कुल गलत बात है. जजेस अभी भी मेहनत से काम कर रहे हैं, अभी भी वो बिल्कुल सही फैसले करने की कोशिश करते हैं. अब लोगों को तो कोई रोक नहीं सकता, क्योंकि लोग आजकल बहुत ही, जैसे मैंने कहा, मादर पिदर आजाद हुए हैं. हर एक चाहता है कि फैसला उसी के हक में हो. अगर उसके हक में ना हो, वो समझता है कि जज दूसरी तरफ मिला हुआ है.
आवाम से आप क्या कहना पसंद करेंगे यहाँ पे कि वो कैसे, उनका इत्मीनान कैसे बहाल हो? ये सिर्फ सियासी फैसलों की बात नहीं है. लोगों को जब लिटिगेशन में जाना पड़ता है, जब लोग किसी जुल्म के खिलाफ, किसी नाइंसाफी के खिलाफ, किसी गैर कानूनी चीज के खिलाफ अदालत में, किसी भी अदालत में जाते हैं और वहां पे वो अगर पिटीशन दायर करते हैं, तो इंसाफ इस हद तक देर से मिलता है कि इंसाफ का मकसद ही खत्म हो जाता है.
ये तो हमने दो बातें की. एक को डिलेज की बात की, कितना ताखीर से मिलता है कि वो जो है उसका मकसद ही फौत हो जाता है. उसमें तो और अवामिल है, मगर ये कि उन जजेस जो है ईमानदारी से काम नहीं करते, ये एक दूसरी बात है. मैं समझता हूँ कि ये जो डिलेज हो रही है वो इसलिए है कि जजेस कम है, काम बेशुमार है. आप देखेंगे हर एक हाई कोर्ट के जज के पास तकरीबन 40 मुकदमे रोज होते हैं. अगर आप किसी यूरोपियन कंट्री में जाएं तो 40 मुकदमे वो सारे महीने में नहीं तय करते.
किसने रोका है कि जजेस ना ज्यादा रखें? मतलब कोई ऐसी पाबंदी है कि जजेस ज्यादा ना रखे जाए?
नहीं, मेरे ख्याल में वो इकोनॉमिक हालात है ना, यानी कि अब जज की
रेलिवेंट वहाँ से
आप बता सकेंगे कि
आ जाती है, यानी काफी तनख्वाहें भी काफी है.
वो मिनट्स आपको पता है कहाँ से?
तो बहुत सारी बातें हो रही हैं. रेलिवेंट कितने देर बाद आएगा?
मैंने आप सर्च किया, जो मैंने फाइल की है ना,
नहीं, किस नंबर पे आएगा? कुछ आपको पता है? 5 मिनट बाद, 10 मिनट बाद?
ये पूरी तो मैंने नहीं देखी हुई. पूरी जो वीडियो जो अभी जियो ने दी है,
ड्यूरेशन बता दीजिए ना आप कितने मिनट्स के बाद है, तो उसको आगे कर लेते ना।
जो पोर्शन आपको आपके समझते हैं फेवर में वो कब आता है, आपको पता है या नहीं?
इस मैंने जो आप खुद फाइल की हुई है
इसका बता दें, पता
इसमें
है?
मुश्किल होगा मुझे बताना सर।
आपकी यूएसबी में है?
जी हाँ, जो मेरी यूएसबी में है ना, मेरी यूएसबी आप चला लेना, वो
पर्टिकुलर यूएसबी है सर, उसको लगवा लें जो इनकी है।
उसके अंदर पर्टिकुलर जो मैंने यूएसबी फाइल की हुई
दे दें, आप निकाल के दें यूएसबी।
मैंने दी हुई है सर, क्या कहते हैं
ये एक सेकंड ये इनकी यूएसबी लगा
ये डायरेक्ट हो जाएगा ना। ये सही है।
Constitution, law, and Pakistan affairs must be placed before this court, and that is a book written by him. He has explained all these matters in details, in writing.
Suri sir, we
that book
definitely hear you. Abhi we are just trying
That
to.
book should be placed before all the judges, and
वो आपने आप
kindly
हमें
read
बता
from
दीजिए,
page 182 onwards.
आपने फाइल की हुई है?
जी,
आपने फाइल
मैंने एक्सेप्ट लगाए अपने अपने
सीएमए नंबर
ये तो आप देखिए,
में
मेरा ये
बताइए।
है 5788।
एक सेकंड,
वो किताब पहले की है या इंटरव्यू पहले का है?
नहीं, किताब का नाम बताएं।
किताब का नाम है जी कॉन्स्टिट्यूशन, लॉ एंड पाकिस्तान अफेयर्स,
Who's written it?
बाय चीफ जस्टिस डॉक्टर सैयद नसीम हसन शाह।
ये इंटरव्यू उनका बात का है या किताब पहले की है कसूरी साहब?
जी,
इंटरव्यू बात का है या किताब बात की है? पहले कौन सी चीज आई?
I wish I could give a positive answer, but this is his written statement, see, and in my
इंटरव्यू की डेट क्या है, किसी को पता है?
When was this
इसमें
book
अंदाजन
published?
आफ्टर 22 मिनट्स जो मैंने अभी
इंटरव्यू की डेट क्या है?
किसी सर
ये जो चल रहा है इंटरव्यू, ये कब का इंटरव्यू है?
ये जो हमने देखा, ये कब इंटरव्यू लिया गया था?
सर आफ्टर दी
3/12/2003।
एग्जैक्ट डेट सर अभी मुझे
3/12/2003।
ये इसमें इसके खत में क्या लिखते हैं?
ये बुक कब पब्लिश हुई है?
ये मेरा जो रिटर्न रिप्लाई है उसके पेजेस हैं सर 42
नहीं, ये इंटरव्यू
42 से लेके
3/12/2003 का। अच्छा, ये नोट कर लें डेट, ये जो इंटरव्यू है 3/12/2003 का, ठीक है? वो जब वो तैयार हो जाए बताइए। तैयार है? उसी कॉपी क्यों कर रहे हैं? अच्छा, ओके। अच्छा, आप कौन सी चीज बता रहे थे कसूरी
ये
साहब?
पेजेस हैं।
नहीं, नंबर बताएं पहले ऊपर। आपका सीएमए का नंबर क्या है? या
ये मेरा नंबर है जी, अपना CMA नंबर
ये निकालिए जरा।
5788 or 2001,
5788/2001,
which I filed before this honorable court on 31st of December 2011.
जब तक वो निकाल रहे हैं हम ये देख लेते हैं।
And the extracts of the book are mentioned in my rejoinder from page 42 to page 57.
इसमें तो नहीं, तो मार्केट 5788 इसमें होगा।
इधर देखिए इस बंडल में, इसमें तो नहीं है।
My lord will read this.
इसी में 5788 की बात कर रहे हैं।
In my rejoinder from pages 42 to 57, these are all the extracts which I have collected from the book of late Chief Justice Sayyid.
थी ना लास्ट टाइम की, वो कहाँ है बुक?
ये वाली, जैसे ओपन वाली।
अच्छा, ये
बात सुने
जी,
ये USB जो है USB में दो
And that's very important, sir, because
Page
that will
42.
wash away all this interview, etc.
42।
42.
इस किताब का पहला पेज तो हमें बता देना, किसकी किताब है, कौन मुसन्निफ है, कुछ तो बताए ना।
मुसन्निफ उसके जी डॉक्टर साहब हैं।
पहला पेज लगा दिया करें ना। चले पेज 42 पे क्या पढ़ना चाह रहे हैं, पढ़ें। पढ़िए पेज 42 पे, आप पढ़िए।
मैं बड़ा लंबा चौड़ा है, मैं
रेलिवेंट आप क्या पढ़ना चाह रहे हैं हमें बताइए ना। रेलिवेंट चीज
तो जी 42 पर लास्ट 3 लाइन्स It is my view. यहाँ से पढ़ना चाह रहे हैं. In my view, that judges do not have a crystal ball to look into the future. We must determine a matter in the circumstances submitted before us and leave to the history to judge whether correct decision was taken.
You see, what does this mean? ऐसी ये relevant बातें बताएं ना.
आगे आ जाइए जी. ये मैं आता हूँ जी.
46 पेज पे आपने कुछ मार्किंग की हुई है. 186 है इसका टाइप पेज.
ये देखें यहाँ पेज, दिस इज पेज 56. The proposal, may I read? Sixth line. This is sixth line from the top. Page 56 of my rejoinder. Page. This is page. ये किताब का पेज.
उसने कहा कि हमसे की इंसान है, अनुभव है, 53 पे.
Mr. Kasuri, if you have, you don't please stand here and look for the page. आप आराम से बैठिए. If the relevant page is, just tell us. Otherwise, we'll waste a lot of time just looking for what you want to read. आप आराम से बैठिए and let us know what page you want us to read.
I'll read the relevant portion, sir.
I don't want you to read the whole book. Just tell us what particular paragraph, page you want to read.
मैं वही बता रहा हूँ जी.
बताइए जी.
तो ये है अपना पेज 52 of my paper book.
जी पढ़िए. कहाँ से पढ़ना चाह रहे हैं?
ये है 1 2 3 8 8th line from the bottom, 8th or 9th line.
पढ़िए.
I told Justice Durab Patel that finding Mr. Bhutto not guilty was not consistent with the thinking of the four Punjab judges, since all of them had come to the conclusion that the evidence in the High Court of the officials of the Federal Security Force who had participated in the killing proved their guilt. And these officials had no motive of their own against Ahmad Raza Kasuri. Undoubtedly, it was only the wish of Bhutto which they had carried out.
What do you want to show from this? How does this language come undoubtedly? It could be the wish of 101 other persons also. So what do you want to show us from it?
I'm coming, sir. Gradually, see, that's
जुबानी बता दें क्या कहना क्या चाहते हैं.
ये है जी अपनी पेज 53. Page 53. Last from the bottom, 9th line. While the majority judgment was written in the name of Inal Haq CJ, in fact it was collective effort of all the four judges who had found Mr. Bhutto to be guilty. Chief Justice had assigned various issues in the case for being dealt with by his colleague, and we had written our portions of the judgment and delivered it to the Chief Justice. The majority judges was therefore a collective effort wherein Chief Justice had merged all the portions into one consistent whole after appropriate vetting. अब उन्होंने कहा कि चीफ जस्टिस ने हमें
know English language, you don't have to translate it.
हमें बांट दिया, हमने
We understand the
Now
English.
the position is कि अगर इनको pressure थे, he should have recused himself. He should have recused himself.
Don't give us that advice.
देखे
That is irrelevant.
नहीं पोजीशन ये यहाँ ये है कि वो
Are you
कह रहे हैं
saying
कि
that this
Chief Justice ने
helps
कहा
you or doesn't
कि
help
since
you?
it's a very longest case उन्होंने 4 पोर्शंस में दे दिया और हम सब ने अपने अपने जजमेंट लिखे और उसको चीफ जस्टिस ने उनको कंसोलिडेट कर दिया उसी that's what he's saying.
फिर क्या होगा? फिर क्या होगा?
So he's a party to it.
ठीक है.
He's a party to
That
it.
is recorded in the judgment itself. He's a party to
He's
it.
a party to it. So therefore
Mr. Kasuri, make the point, please.
मेरा पॉइंट ये है कि सर if at all there was any pressure he should recuse himself.
We've noted that point.
Then there's another argument. Who is the author judge in this? That is the Chief Justice of Pakistan. Now, if he had decided on pressure, that means that he served General Zia and taken the throne from his side. Now, what history
Mr.
tells us?
Kasuri, are you going to make the point or not?
My point was, history tells us that after few months later, PCO was promulgated and Chief Justice refused to take oath. A judge who refused to take oath and go on a premature retirement, do you think on the instructions of or on the pressure of somebody he will go and pass a judgment of death? That's the point.
Now can we continue? आप तशरीफ रखें. This is not your reference, this is the presidential reference. So you don't have a right of audience to begin with. You will be heard at your appropriate time. So अगर आप हर दफा में interrupt करेंगे तो हम please जरा ठहर जाइए.
इनका जो decision
This is not a case. This is not an adversarial proceedings.
जवाब दिया उसकी भी कॉपी मुझे देनी चाहिए थी. I should be provided with the copy which Mr. Bilawal Bhutto has placed before this court.
Yes, it's been filed. दे दीजिए इनको सेट अगर नहीं है एक्स्ट्रा आपके पास पड़ा हुआ है.
I should be
आप ये काम इनसे कहिए ना, हमसे तो ना कहिए. हमसे ऑफिस का काम ना करवाएं. अगर कोई मसला हो रहा है नहीं मिल रही फिर हमें बता दें, हम आपको दिलवा देंगे. अच्छा वो हो गई जगह. हाँ चलिए लगाएं. This is not the same book.
These are 3 different books. लेकिन ये वाला पेज इसमें नहीं, वो मेमोइर्स है. लेकिन that paragraph page 53 is a relevant paragraph, which is collective.
एसपी का चलेगा.
ये मैंने कभी जजमेंट लिखी थी, ये तो नहीं था कि वो पीले ने अपनी जजमेंट लिखी था, मैं जोर के कहता हूँ.
मालूमात कीजिए कि मसला है तो बाद में इसको कर लेते हैं. चलिए वो कौन थे इधर? हाँ चल गया.
साहिबान क्या करें, आपकी एक ऑब्जर्वेशन.
जी हाँ, ये मेरे ख्याल में बिल्कुल हकीकत पे मबनी है.
कच्चू किताब है ये आपके रिव्यूज के बारे में. जरूरत का पेपर आपने कहा कोई आ जाता है कि जनाब मार्शला गैर कानूनी है, उन्होंने आइन की खिलाफ वर्जी की है, आइन को तोड़ दिया है, लिहाजा आप मार्शला को गैर कानूनी करार दे, और उन्होंने जो कार्रवाई की है उसकी उन्हें सजा दें। जज साहिबान बैठे हैं, ऊपर मार्शल लॉ वाले तोपें बंदूकें लेके खड़े हैं, तो फिर जज साहिबान क्या करें? आपकी ये एक ऑब्जर्वेशन।
जी हाँ, ये मेरे ख्याल में बिल्कुल हकीकत पे मबनी है कि लोगों का तो ख्याल है ना कि जजेस को तलवारें चलानी चाहिए और मिलिट्री वालों को यानी रेस और नाबूद कर देना चाहिए, इन्होंने गलत किया है। मगर वो मिलिट्री वाले हैं, वो जजों को निकाल सकते हैं। और दूसरा ये है कि लोग बिल्कुल कुछ करते नहीं। जब तक पब्लिक ओपिनियन ना हो, वो कोई भी कोर्ट या कोई भी अदारा अपने
तो सर मैं
पूरा तरह
आराम से एक बात कहना चाहिए कि जज पर ये लाजिम नहीं कि जज इंसाफ करे।
लाजिम तो है, मगर कई दफा अपनी जब यानी नौकरी का मसला आता है तो तमाम जज साहबान जो है वो इतने बहादुर नहीं होते कि अपनी नौकरियों को कुर्बान कर दे और इंसाफ करते रहे। मैं आपको सच्ची बात बता रहा हूँ, लिहाजा वो यही समझते हैं कि अपनी नौकरी को बचा लेना चाहिए, क्योंकि शायद मेरा यहाँ रहना कौम के लिए और इस अदारे के लिए बेहतर रहेगा। क्योंकि अगर मैंने निकाल दिया और मेरी जगह कोई नफ्तू ऐसे कोई आ गया तो वो जो भी फौजी कहेंगे वो करता रहेगा। तो लिहाजा बेहतर है कि एक आध केस में जिसमें फौज ज्यादा इंटरेस्टेड है उसमें कोई थोड़ा सी लचक दिखा दी जाए, मगर यानी अपनी सीट बचा ली।
तहरीर क्या ये आप
जी, ये बस आपने तो ये दिया है। पोर्शन आपने ये तो नहीं गलत वाला बताया मैं।
सर यही जो इंटरव्यू दिया,
तमाम जज साहबान जो हैं वो इतने बहादुर नहीं होते कि अपनी नौकरियों को कुर्बान कर दे और इंसाफ करते हैं। मैं आपको सच्ची बात बता रहा हूँ, लिहाजा वो यही समझते हैं कि अपनी नौकरी को बचा लेना चाहिए, क्योंकि शायद मेरा यहाँ रहना कौम के लिए और इस अदारे के लिए बेहतर रहेगा। क्योंकि अगर मैंने निकाल दिया और मेरी जगह कोई नफ्तू ऐसे कोई आ गया तो वो जो भी फौजी कहेंगे वो करता रहेगा। तो लिहाजा बेहतर है कि एक आध केस में जिसमें फौज ज्यादा इंटरेस्टेड है उसमें कुछ थोड़ा सी लचक दिखा दी जाए, मगर यानी अपनी सीट बचा ली।
जुल्फ़िकार भुट्टो केस में मौजूद थे
जी।
आपसे अगर ये पूछा गया जाए कि क्या पाकिस्तान की अदालती तारीख में ऐसी कोई मिसाल है कि महज मशवरे की बुनियाद पर किसी को फांसी दी गई है?
जी हाँ, मेरे ख्याल में ये मशवरा तो नहीं था, उसमें तो वो था कि उनका ऑर्डर था कि वो यानी अपने यानी सबॉर्डिनेट्स को इसको रजा कसूरी को खत्म कर दिया जाए। तो लिहाजा मशवरे की और बात होती है, ऑर्डर की और बात है।
साहब ये जो जब मैं अगर मैं मुजरिम हूँ, मैं एक्यूज हूँ, मैं कहूँ कि मुझे आप पर एतबार नहीं है, मुझे आपसे इंसाफ की तवक्को नहीं है, तो आपको बतौर जज क्या करना चाहिए?
ये डिपेंड करेगा ना कि क्या आप देखते हैं वजूहात।
मुल्क का वज़ीर आज़म हूँ, आपके सामने पेश हूँ, मैंने आपको प्रमोशन नहीं दी, आपको बिठा दिया गया, मैं कहता हूँ मुझे आपसे इंसाफ की तवक्को नहीं है, तो आपको क्या करना चाहिए था?
तो मैंने नहीं ख्याल किसी को उन्होंने कहा ऐसी बात कि आप मुझे तवक्को नहीं, बल्कि उन्होंने तो बड़ा हमेशा कहा है कि मुझे सुप्रीम कोर्ट पे पूरी।
मौलवी मुश्ताक साहब की मैं बात कर रहा हूँ, मौलवी मुश्ताक साहब को जुल्फ़िकार भुट्टो ने ये कहा।
जी हाँ, वो मेरे ख्याल में मौलवी साहब की रियासती।
That's it. You've not even given the correct recording.
Sir,
There is more.
It was removed from the YouTube.
नहीं, please show us. ऐसे तो ना करें, because this is not even relevant. The one portion, I don't know if it's correct or not. अब हम अपने तौर पे सुन लेंगे. Let's continue with Mr. Makhdoom Ali Khan.
है इसके आगे काफी है जो भी।
Yes sir, देखें वो जो है ना, मैं आप सर्च करूँ ना जो।
The question of pressure is a portion which you've not produced in it.
मैं अर्ज करूँ ना, ये जो
अर्ज क्या करना है ना, factually आप हमें वो गलत चीज दे रहे हैं।
नहीं सर, देखें जो YouTube पर जो मेन इंटरव्यू था वो रिमूव कर दिया गया था, हमारे पास अब उसकी कॉपी नहीं है। What we could get, we have given.
Geo has sent the whole copy.
सर हमें कॉपी नहीं मिली है ना सर, प्लीज।
अच्छा ऐसा करें, आप ऐसा करें कि
मैं इसको
वो जो- नहीं, एक सेकंड ठहर जाइए, ये जो जियो वाली कॉपी है इसकी कॉपी बना लें 2-4, ये जो आई है जियो से, ठीक है। और फिर हमें ये अभी 1 घंटा तो हमारे पास नहीं है सारे को सुने, जो रेलिवेंट पोर्शन है आप हमें ये बता देंगे 10 मिनट पे, 20 मिनट पे, जो भी मिनट पे, वो हम नेक्स्ट डेट पे कर लेंगे, नेक्स्ट डेट पे कर लेंगे। आज आप ले जाइएगा, प्लीज हियर इट केयरफुली एंड गिव अस एग्जैक्ट टाइम लाइन। नेक्स्ट आइए मखदूम
दैट विल बी डन सर, थैंक यू।
जी।
My Lord, may I, with your Lordship's leave, begin with the questions. I have noted the questions at that time. My Lord, Mr. Sayyid Mansoor Ali Shah asked the first question, what is the window available to us in this case? My respectful submission would be that the window is the window of the principle of nemo iudex, that whether the acted in accordance with the due process of law, or were there any external pressures? When your Lordship sees that interview, whether that window is open or not will become apparent. My respectful submission.
Other than the interview, you don't have to say anything else?
My Lord, yes. The other is, your Lordship said what can be fixed, my Lord the Chief Justice. Your Lordship said the sentence has been executed, and your Lordship said what is to be fixed. My Lord, your Lordship is right, that cannot be fixed. But what can be fixed, as your Lordship identified for the purpose of posterity and history, is the precedent of this Honorable Court, the jurisprudence of this Honorable Court, and of course the reputational damage which will continue for all times to the accused and his family. So that still remains.
Reputational damage of the Supreme Court or reputational damage to the heirs of the deceased?
My Lord, reputational damage with great respect to that of the Supreme Court as well as the deceased.
Please expand.
My Lord, over a period of time, and I'll show to your Lordship that these considerations are relevant, several writers writing books, journalists, history, interviews of judges, the kind of letter that your Lordship saw, all indicate that this was an unsafe conviction. As I proceed further, I'll show to your Lordship from precedents from other jurisdictions.
Will we benefit by opening old wounds, or we will suffer?
My Lord, my submission is that...
Court I'm talking in particular.
Yes, my Lord, my submission is that once this presidential reference is here, if your Lordship takes the view that this was a miscarriage of justice and fixes it at least for the purposes of posterity, the reputation is enhanced, not diminished. Your Lordship has done that.
Who would be at fault, the Supreme Court or the prosecutor, the martial law administrator of the time?
My Lord, there are cases at times when it is difficult to say who is at fault. I had the honor on behalf of the International Commission of Jurists to attend a trial in Malaysia where the Bar Council was being charged with contempt because your Lordship remembers there's an infamous episode in their history as well where the Chief Justice was removed and 4 judges who sought to protect the Chief Justice were also then removed. The Learned Counsel appearing for the Bar Council at that time said that, sir, this is one of those cases where all of us on trial here. So this is a case where society as such, lawyers, judges, politicians, people in power at that authority, all of them had their respective role to play, and this Honorable Court, with the benefit of hindsight, can fix that error. My Lord,
whether this judgment has been cited anywhere in Pakistan, in any court of law, this judgment has been cited,
my Lord,
as a precedent.
I conducted a quick precedent search. On the next date of hearing, I'll give your Lordship a chart as well. I could not find a judgment where this has been cited with approval to uphold the conviction of an accused.
Which means it has already been discarded. In a manner it has been discarded. It has not been believed by the court.
My Lord, dilutions take place, as last week your Lordship was hearing a case, your Lordship have noticed, and they take place in both ways. Your Lordship saw that in the case of Ishaq Khan Khakwani, a learned judge, expressed a view that this entire article of the Constitution was illusory in nature, was more inspirational. In Muhammad Nawaz Sharif's case in Panama 1, that very same judge, first as part of a dissent and then as part of a unanimous court, walked away from that precedent, and he said this was only to point out what the legislature could do, and as a judge I will have to implement it. My Lord, your Lordship have seen it happen in the other way as well, that in a 5-member bench an author judge took a view in Samiullah Baloch, and then in a series of judgment, then he diluted its effects.
What's the relevance of these cases?
My Lord, that your Lordships have distanced yourself from a particular jurisprudence. In response to my Lord Mr. Mandukhel's question.
If at all, in our opinion, we will touch the judgment.
My Lord?
We will touch the judgment.
My Lord, your Lordships don't have to.
It remains as it is.
My Lord, that judgment has been executed.
Yes.
That the sentence has been carried out. That person is no longer alive. What we are here to fix, if your Lordships so consider appropriate, is one, the jurisprudence of this Honorable Court, and second, the reputational damage to the family of the accused.
To the reputational damage, or can we override that sentence that has attained finality?
My Lord, your sentences...
Also come, the doctrine of finality will also come because 3 stages have passed. Original, appellate and the review jurisdiction.
My Lord, sentences, even when your Lordships are hearing an appeal, are never reversed, in the sense that a person may have undergone a number of years of imprisonment. Your Lordship can't restore his liberty to him.
And there is also
but convictions can be set aside.
Conviction
can be set aside.
We also undergone, so there are 3 dimensions of the criminal cases.
For setting aside the conviction, we will have to touch the merits of the case.
Your Ladyship,
after 45 years.
If a conviction is reversed on the ground, or a different view is taken about that conviction, or an opinion is expressed about a conviction that it was unsafe, and therefore it ought not to have been, that order ought not to have been passed, that is enough. Your Ladyship doesn't have to go any further.
Under reference can we do this because there is no curative jurisdiction in our constitution?
My Lord, your Lordships have done that through a number of windows, which takes me back to my Lord Mr. Sayyid Mansoor Ali Shah's question. Your Lordship recently in Rekodik case, where a statute was under examination before your Lordship, with certain reservations, moved away from the earlier judgment of this Honorable Court in the Rekodik case, realizing the financial damage it has caused to the country. In a case where my Lord Mr. Sayyid Mansoor Ali Shah dissented, this Honorable Court dismissed the review petition, but under Article 184(3) revisited its earlier order. Your Lordship dissented, I know, but the majority took a different view. In the judge's pensionary benefits case, the review had also been dismissed. But your Lordship said under 184(3), we can...
I mean, I might not agree with that, but that's all happening within the jurisdictions that we enjoy.
Yes.
So we're talking about 186 as a policy, then we're saying that President tomorrow would send another reference saying a particular decision is not correct. In order to establish miscarriage of justice, we'll have to delve deep into the facts of the case and then say, yes, it was not rightly decided. So what's the finality given to judgments? You see, the question is, I mean, I'm all for the miscarriage issue, but the question is, does our constitution allow that? Can we get into it and tomorrow revisit our judgments through the presidential reference and upset their finality? Because in order to do that, you'll have to go down. Other than the fact that the judge said or did not say anything about pressure, then we'll have to go and see the merits of the case itself. Maybe he might or might not be under pressure, but the merits might say otherwise. So, aap visit to kar rahe na sara factual disputes. How is that possible?
Sir, not the evidence and not the facts, but my submission is that if on the basis of the material on the record, your Lordship reaches the conclusion that this was a case where the effect was that judges have acted under a, or even